In this session, we will address emergency arbitration, what it is, and how to use it. By way of background, my name's Duncan Speller. I'm an English barrister and a partner and global co-chair of the International Arbitration Group at Wilkie Farr and Gallagher, based in London. I have experience both as appearing as counsel in applications for emergency relief from an emergency arbitrator and also appearing myself as an emergency arbitrator. So I will draw on that experience to give some practical insights into what emergency arbitration is and how to use it. And in this webinar, we will cover in particular the definition of emergency arbitration, the requirements for emergency arbitration under different sets of institutional rules, forms of emergency arbitration that can be sought, typical costs and timeframes for obtaining emergency relief, importantly, practical tips in presenting or responding to an application for emergency arbitration, the perspective of the emergency arbitrator and the factors that the emergency arbitrator will consider in determining whether to grant an application for emergency relief, and the interplay between emergency arbitration and arbitration, as well as the effect of emergency relief on the arbitral proceedings. And taking a step back, emergency arbitration can be a very powerful tool for a claimant which wants urgent relief that can't await the constitution of the tribunal, such as preservation of evidence or the status quo. At the same time, it's important for a claimant to be very aware of what the requirements of emergency arbitration are and how to meet those requirements, because the consequences of bringing an unsuccessful application for emergency relief can be an adverse costs order and losing the opportunity for a victory at an early stage of the arbitration. So firstly, if we turn to the definition of emergency arbitration, what is emergency arbitration? Well, emergency arbitration is a mechanism that allows parties to seek interim or conservatory relief on an urgent basis from an emergency arbitrator specifically appointed for the role before the constitution of the arbitral tribunal. So the gap that emergency arbitration is intended to address is the period between starting the arbitration and the tribunal being constituted. And it's intended to provide a route for a party that feels it can't wait, that the effectiveness of the arbitration will be undermined if it waits, to seek emergency relief during that time period.